Alright, hello and welcome to this evidence video capsule. Now this is a bit of an advanced capsule that explores in a little bit more depth a part of the modern approach to the hearsay rule. And I'm going to focus on a very specific aspect of the principled or residual exception to the hearsay rule. If any of what I've just said is new to you, you should probably go first watch my video capsule on the principled or the residual exception to the hearsay rule, because you've got to know that first. Now, my focus is on a 2016 decision from Ontario which looked at a very specific question. When will evidence that fits within a traditional exception to the hearsay rule and therefore qualify as admissible, in what circumstances will it be excluded because there are sufficient concerns about its reliability? To put it another way, when should a court exclude evidence through an exception to a hearsay exception? If that doesn't sound confusing, well, it probably does sound confusing. You should look a little bit further. So first let me tell you what it is I'm talking about. And for those of you who are familiar with the hearsay rule, you know that the hearsay rule means that evidence is prima facie excluded unless it falls into an exception. And historically, the way in which we dealt with exceptions were by virtue of what are sometimes referred to as pigeonholes, meaning that you needed to fit into a traditional exception, and if you couldn't fit into one of these designated exceptions, and there are quite a few out of them, you are out. What happened during the hearsay revolution is that we moved instead to a principled approach of what's called necessity and reliability. If you can meet the two criteria for which we consider hearsay exceptions, the evidence is reliable and necessary, it will be admitted even if it doesn't fall into a hearsay exception. But the important part for this podcast is what happened in the case of R versus Starr, which sort of reconciled the way in which we deal with the categorical pigeonhole exceptions and the principled residual exception. There was a lot of talk at that time about just saying, look, let's get rid of all these exceptions and let's just live with the principled exception, because theoretically all of these are based on principles anyway. If the evidence is necessary and reliable, that should be the new touchstone for admissibility. Let's get rid of everything else. But a lot of people didn't want that, and a lot of people said, no, what we need to do is retain the hearsay exceptions, and the reason for that is predictability. So therefore, what we're going to do is we're going to have a new balance where we're going to use old hearsay exceptions, these here, and new hearsay exceptions, this one here. And we will have this sort of uneasy balance. And in the early days, it wasn't really sure how that was going to work. But here's what the court said in a series of cases that ended in a case called Mapara, which is an important case on the subject. So here's what Starr and Mapara sort of did together. Number one, traditional exceptions remain in place. But number two, since the principles of necessity and reliability are supreme, it's a good idea to challenge and modify or get rid of old exceptions wherever possible. Now, I would argue this hasn't happened as much as it should, but a few exceptions have unquestionably been modified to accord with the necessity and reliability approach. Courts have avoided quashing old exceptions altogether, even some really sketchy ones like ancient documents, etc., and dying declarations. And what they've done instead is said, well, we're just not going to consider the evidence under this old exception. We'll just move to the residual exception, which still exists, and we'll see if it can be admitted under that. But arguably, what you're supposed to do is fix the exception so you can create guidelines that continue to be useful for other future cases. But the point I want to talk about today is C. In rare cases, even where the evidence comes in an exception, it can be excluded. You can exclude it, even if it fits under a traditional exception, if it's unreliable and unnecessary. And the question that the case of Lougaranth deals with, the one I'm talking about today, is when. When should this take place, and how often should we exclude evidence when it does fit into a traditional hearsay exception? And the problem here is, if you think about what Starr and Mapara were really trying to achieve, they really wanted to keep this stability and predictability because lawyers understand hearsay exceptions, and believe it or not, they're quick and easy to apply. And I've argued for a lot of people who think we should just move to a fully flexible system, which sounds great, reliability and necessity, but just ask my evidence students. It's really hard to attack every hearsay exception from first principles, and the traditional exceptions are useful in providing stability and predictability. But the question of this residual exclusion to an exception exception, if you understand what I mean, it fits into an exception, but we're going to keep it out anyway, is that you risk altering this balance. And again, commentators, including Justice Laura Dubé and Starr, said if lawyers get a hold of this, they're going to try to undermine the traditional exceptions by saying, well, this is the special case in which we could exclude evidence. Well, what I can tell you, looking back now over the years since Starr was decided in 2000, that hasn't really happened, and I'm going to show you why. The truth of the matter is my theory, and I think the Lougaranth case sort of supports this indirectly, if you have a good case to exclude evidence that fits into traditional exception, I would suggest that what it really does is shows a weakness in the traditional exception that should be modified in most cases. And that's what I think this case sort of shows. The arguments to exclude the evidence, which I'm going to show you, don't really change the nature of the traditional exception. And the court just says, no, what you're trying to say is the traditional exception is no good, and frankly, there's no good reason to come to that conclusion. So Lougaranth, sorry, I've already butchered that name, is a very recent case from 2016 where it's very straightforward. You have a witness, an uninterested witness, who sees a fight, and he writes down the incidents in detail. So the exception we're going to deal with is called past recollection recorded, and it fits all the demands. In fact, the defense concedes that it meets the demands of past recollection recorded. Well, the stupid case takes 3 years to get to trial. I don't know what happened there in terms of, staying it for delay, but whatever, took 3 years to get trial. He testifies he cannot remember who started it, okay? But he does affirm that what he wrote down in detail was correct. It's pretty classic PRR. The only thing the Crown's admitting it for is one tiny aspect of the case, and the fact that he can affirm what he wrote down was correct, and he's under oath, he can still be cross-examined about most of what he said and saw, meets the dictates of past recollection recorded. And the reason for this, just very briefly, it was recorded in a reliable way. He wrote it down on his computer within a reasonable time. He can vouch for the accuracy when it was made, and he has no memory. Those are the 4 criteria of past recollection recorded. So there's absolutely no problem with the exception. But the defense says it should be excluded. Here's the reasons that they put down. Essentially, what they're trying to say is that the reliability, these are the indicators that would normally be considered under a reliability exercise, if we were trying to admit this under the residual exception, wasn't under oath, true for all past recollection recorded, by the way, may have been involved with discussions with others, the content was vague, and he was describing a chaotic scene. In fact, so what he was describing was inherently unreliable and cannot be cross-examined upon. So essentially they point to various weaknesses in the evidence, and they say you absolutely have to exclude it because it just isn't good enough. And the Ontario Court of Appeal says not a chance. And the reason, I think correctly so, by the way, is that all of these concerns, if you really think about it, they go to weight. You're essentially saying that the question here is the hearsay sufficiently reliable to be admitted? And the answer is that it is, for all the classic reasons of past recollection recorded. The person recorded it at a time in which the information was fresh in their mind, they verified that information, and they cannot remember it here today, so we need it. So what we have is, the past recollection recorded doctrine is sound, and the question is, should we kick all this stuff out because of the weaknesses that we can see? And the court says no, that goes to weight. The fact that it wasn't under oath, that's the same for all of this evidence. Content's not descriptive enough, and it's describing a chaotic scene. Now, let me just say, I think there could be an argument to be made that past recollection recorded, certainly the way it's being applied today, is too broad, and it's including a wider range of information than it was designed to capture. But that's an argument about the exception itself, and it is not a situation in which we should go to this rare case of exclusion. And the reason is that we shouldn't really go to this rare case of exclusion very often. Every time you look at it, you're really trying to undermine the nature of the traditional exception. And frankly, the better way to deal with this for all time is to modify the exception if need be, or discard it altogether. The rare case of exclusion has remained exceptionally rare. And that's sort of borne out by the jurisprudence. This case-by-case safety valve really hasn't come to fruition. It just hasn't happened for the reasons that I've set out. Courts look at the situation and say most of the time the weaknesses you're stating go to the weight of the evidence. Traditional exceptions should do the lifting in the most case, and where there are concerns, modify them. That's the better way of dealing with it. Weaknesses in reliability tend to go to weight. And I say that for a lot of reasons. If the traditional exception isn't working properly, then it really should not be allowing in evidence on a regularly reasonable basis. So you just need to modify it. Weaknesses in reliability, like we saw in this case, should go to the weight of the evidence. In short, the residual exclusion clause, which I think the court created as sort of this safety mechanism, so they wouldn't get into the situation where they were admitting evidence in a case that looked dangerous just because it met the nature of the traditional exception. Again, everything I can see shows me that most of the time, weaknesses in a particular fact scenario really show that there are weaknesses with the traditional exception. And the better course of action is not to use this residual clause, which is why I tell my students not to worry about it when they're actually dealing with exam scenarios. Go after the exception itself and fix it so that we don't have these problems in future. In any event, those are my thoughts about hearsay exceptions and the way in which we deal with the exception to the exceptions in hearsay cases. Hope that was useful to you, and have a great day.